Well, our apologies once again. Alicia and I just finished recording another episode of the Canadian Immigration Podcast right before this, and the topic was way bigger than I originally intended. And so there was so much to say, and we just kept talking and recording, and there wasn't a natural, easy place for us to shut things down. And so we apologize for being late for our live Q&A this week. There's been a few changes, Alicia, a few changes in the world of immigration. And I don't know if you could pick number one on this past list. What would be number one on the list for you of changes within Canadian immigration?
Oh, that's a tough question, Mark. I don't know. I mean, we have a new immigration minister. We don't know what to expect from the new immigration minister. We might have a new government. We don't know when there might be an election. There's all sorts of changes south of the border. So, yeah, I mean, it remains to be seen. IRCC has, they're still doing draws in express entry. We had a PNP draw. So things are still kind of proceeding. But we are waiting. We're waiting for a number of things right now to hopefully provide a little bit more certainty or direction in terms of what the future is going to hold. So there's a lot of uncertainty right now.
Yeah, absolutely. It's as we watch these changes, like one of the big ones, if I slip over here and we look at the YouTube channel, one of the things that, one of the big changes that we had, like you said, was our new immigration minister, Rachel Bendayan. And Igor and I, on Friday, I was getting ready to head down south to see my boys. They're going to school in Idaho at Rexburg, Brigham Young University. And we were going down to meet my one son's future in-laws, and then meet my other son's girlfriend that he has for the first time. And it's never fails, like big announcements, big changes. So the cabinet, the big shuffle, new ministers came about. And so we couldn't help but do a quick little live stream to share everything that we knew about our new minister, Bendayan. And I wonder if I do have, yeah, I do. There we go. So we've got our new minister here. So we've got Minister Bendayan here, and I guess this week we'll say goodbye to Minister Miller. I'm sure he'll be very sad that he's not able to join us on our live streams anymore. But lots can be said about the tenure of Minister Miller. And one of the things that we talked about when we were discussing this on Friday in our the new immigration minister video was that Minister Miller really came in at a really tough time. And I've always, I've been somewhat critical of of the decisions that Minister Miller has made, but in fairness to him, he inherited a lot of problems that his predecessors had put in place. And right from the beginning, I always had a lot of respect for Minister Miller because he was not afraid to acknowledge and recognize, where changes needed to be made. And he tended to be the brunt of everyone's ire because he had to reverse all of the other decisions, or they felt they needed to make changes. And maybe lots could be said about the method in which they employed these changes. And I felt, at least myself, that they weren't always well thought out, and that they were a little bit more knee jerk than anything else, that they were a little bit too much politically motivated, I guess, than otherwise. But Minister Miller, I'll give him credit. He accomplished some good things when he was minister, and I think he knew that going in, that was going to be his role. And I guess I'm a little bit disappointed for him in some instances that he has no other portfolio. At least it seems like he's just kind of dropped off, at least with our new prime minister, Mark Carney. He doesn't seem to be in play, I guess, if you will. But he did his role, and now we have a new minister. And so, Minister Miller, thanks for your service. And now it's time to move on, and we'll see if anything. We'll see if Minister Bendayan does anything really substantively with her new mandate, her new portfolio before this election, or whether this is just repositioning, trying to distance yourself from the from Prime Minister Trudeau and the way he had structured his cabinet, and Prime Minister Carney now is trying to reorganize and establish his own kind of his own culture, I guess, if you will, leading up to the election. So I don't know if you have any thoughts, Alicia, on that.
Yeah, I mean, I think until we know when the election's being called, I think there will be very few changes right now in immigration because it's a new minister. They're just going to try to keep the ship afloat and not shake things up too much, I would guess, until they have a clear direction on what's happening with the election.
Indeed. All right. Well, those of you who are tuning in for the first time, great to have you here. Welcome. Please post a comment in the description in the comment section. Let us know where you're tuning in from. We love to see where people are connecting from. Yeah, we've got a lot of people that come back repeatedly. So to those of you who are repeat viewers, we really appreciate you joining us. And the success of these live Q&As, you guys, is really the questions that you bring forward. So when you bring forward questions that are of benefit to everybody that's watching, then it just makes these live streams better and better. And I was looking, Alicia, just at our YouTube, our channel just the other day, and we're up to 980 videos right here. So we're just about at 65,000 subscribers. But on the YouTube channel, I've released, since I launched this YouTube channel, I think it was maybe back in I think maybe 2015 I did. So it's almost 10 years, but 980 videos. We are just about at 1,000. So when we drop that 1,000th video, we're definitely going to have a party. We're going to do something really fun, really cool. So thanks to all of you that have supported us. And this live Q&A we have done for years. And, it's had different times. I used to do it at noon. Then we moved it to 10 a.m. and Mountain Time. And that's kind of where we've situated it. It was on a Tuesday at one point in time. And now it's kind of found a home on Wednesday mornings at 10 a.m. And all of you that are joining us and participating, like I said, you're the ones that really make it what it is. So it's great to have you all joining us. Okay, let's give some shout outs. So Anand says, hey, Mark and Alicia. Hello, Anand. Good to see you. And we will get back to the questions, you guys, for sure. So don't worry about that. Okay, Omar says, I hope the new minister addressed the nightmare with the e-Coper delays. I know, Omar. Every week you come and you say, hey, what do I do when I'm not getting my e-Coper? And, it's interesting, Alicia. Originally, when it was the end of the year and those e-Copers were just going slow, I couldn't help but think it was more of a levels plan issue. That individuals were just being kind of hung up because they were trying to delay and push things to the next year. And then they were going to start to release them because maybe they had already met the levels plans. But now we're into mid-March and they're still not happening. And we're also seeing a flurry of these bizarre emails that are coming to our inboxes from previous clients with respect to settlement instructions and things of that ilk. And, there's just huge issues within the portal. I don't know what's going on. So Omar, I have to assume that the nightmare that you're going through is, if it's part and parcel with what's happening across the board within the immigration systems. And Alicia, the Liberal government has allocated millions and millions of dollars to fix the online systems, to modernize the immigration system. And I don't understand. I've said repeatedly that probably we could get a group of our viewers here with those skills to come in and whip it into shape in about 30 days and be done with it for a tenth of whatever they're paying the current folks. But it's disappointing that we don't have systems that are a little bit more that instill a little bit more confidence. I guess we'll leave it at that.
Yeah,
All right.
and
So
to be fair to immigration, I think a lot of their problem is also making sure they are secure, right? And so this is where a lot of the back end stuff and people gaming the system means that they can't be quite as nimble because they need to make sure that there's a whole bunch of security and hopefully lack of people getting in and doing nefarious things, or even trying to game the system by trying to predict what's happening, like with express entry, for example. So some of that I think is the administrative machine clunking along for sure. So yeah.
yeah, indeed. All right. Prasanna says, hey, M&A. Nice. Mergers and acquisitions. Mark and Alicia, good to see you both. Excellent. There are days, Alicia, I'll be honest, there are days where I kind of look back and I think, Oh, this immigration. I love working with people, but it's really hard these days. It's really tough, because you have so many individuals in such really dire, desperate circumstances, and often we provide a lot of assistance. We're able to guide people, direct them, but sometimes, Alicia, the assistance we provide is just helping them to realize that there is no pathway forward, which without any doubt is valuable, important to understand, so that you're not throwing money at something that has no hope of success, depleting your savings, and then having to go home with nothing. But it's still, there are days, where I worked with a large national firm when I started practice, and I had an opportunity to work, in the M&A floor. In fact, I was on the securities floor when I was a summer student, and I had opportunities to work in other areas, tax and commercial litigation, and and I decided, you know what, I'm going to do business immigration. That was kind of where I started, and they were very supportive of me. But there are some days, and this last couple months are some of those days where I think, oh, what would life have been if I had chosen that path to practice law? But then I have good days like today, and I have these, a bunch of people that are watching a live stream, and I feel like I'm actually making a difference in the world. And and hey, if you feel like you're making a difference and you're having a positive effect in people's lives, and oh boy, I go to the Google reviews all the time, Alicia, and see the comments that people share with us, and it just, yeah, unbelievable. It just makes me so grateful that I chose the area of practice that I did. So that's Mark's little monologue this morning. Ginny is up in Edmonton. Great to have you, Ginny. Connecting on X, very cool. I love it when I can see the different platforms that we're reaching, not just YouTube. We're trying to stream on Facebook and LinkedIn as well. Parth says, hey, Mark and Alicia. Parth here from Sarnia, Ontario. We've got Cram, who's up in Athabasca, Alberta. And I love the name Cram. I don't know if I told you before, Alicia, why I love Cram so much.
You did last week. He was here too, and
Yes,
so you're talking
that's right.
about
I think
Mark's full
Cram.
time.
I think Cram is back. So that's Mark backwards. That's why I like it. And then AC says, Mark and Alicia tuning in from Toronto. Great to have you there. Patricia says, from Virginia, grew up going to Canada, Port Elgin every summer. I miss it and want to go back. Well, ironically, Patricia, my one son's girlfriend is from Virginia. And so I was looking at the road trip that would be necessary to drive out there if there was a wedding out in Virginia, for instance. And yeah, it's over a day. I think it's a day and a half drive. So definitely not something you're going to do in an overnighter. So we'll see how that plays out. Let's see here what else we've got. So yes, if you're new, please jump in, and we'll get to questions in just a second. Let's see if we've got any other folks saying hello. Sarita says, hello, I finally could catch you live. Hey, that's awesome. We're happy to
And
have you connecting in.
I think we've got an AC and CA tuning in
Yeah,
from Toronto as well.
yeah, I saw that, AC and CA. That's great. Okay. All right. So let's start from there. And the purpose of this, you guys, is to try to provide direction and information on immigration. It's not to give legal advice, which that's why we have our website, holthelaw.com, and there's a link below. And if you happen to ask a question and I ring that little bell, that's your indication that that question is really too specific for us to address. And it would require a consultation so that we can understand the full context of your circumstances so that we can give you proper legal advice. There's nothing more dangerous than you asking a question, can I leave Canada and come back? And we say, sure. And then you leave Canada, and then we don't realize there's a whole bunch of other issues at play here. And then you try to come back, and then a border officer says, nope, you're not admissible, or the airline doesn't let you board. And then you say, oh, that Mark and Alicia, man, they're lousy. They told me to go, and now look at the harm they've caused. So guys, that's why we don't answer the specific questions that really necessitate a full consultation. So we get all the facts, and then we can give you actual proper legal advice. So with that being said, Alicia, we talked about a couple changes, and one I did want to address in addition to the minister was the rounds of invitations. And
Mhm.
if you look here and we go to the actual the site, just 2 days ago, and I honestly, I'll be very surprised if we don't see something more today, but there was a provincial nominee program only draw, very small number of nominations, invitations issued, 536, and CRS score of 736, which these scores are quite surprising to me. And I guess really they shouldn't be. But when you look at 736, what this means is, at least with what was disclosed in express entry, the person has a comprehensive ranking system score of 136 points, aside from the 600 points that they would get for the nomination. So, often we see these upwards of 900 or 1,000 points, but the lowest one, so it's pretty low. And so, why do you think, Alicia, notwithstanding the fact, if we go to these previous rounds and we look historically, you can see there have been consistent PNP draws of
Yeah.
very small numbers. So why is that, Alicia?
And that's going back to the levels plan. And so we pull this up often, and I think we talked about it last week as well, but there are basically 50% of the provincial nomination allocations distributed across to various provinces. And so, like we talked about in the last live, some of those are pulled back up because the way that IRCC wrote the levels plan, they kind of rejigged the categories a little bit, and so it's difficult to tell exactly where the numbers are being lost and where they're gaining. But we know that some of those are being pulled back up in their federal economic priorities, and so some of those PNPs now, the overall number has dropped from 110 to 55,000. So yes,
Yeah.
that has gone down under the full PNP classification, but hopefully some of those are being drawn back up because of the reclassification of in Canada focus versus federal economic priorities. But overall, it does mean there will be fewer straight PNP draws.
Mm-hmm. And so if you have fewer nominations being issued, then of course, these rounds of invitations, which the government has, consistently committed to doing these regular rounds for PNP applicants, when you have these regular rounds and, all across the country, PNPs are really reducing the number of nominations that they are extending because their allocations have been cut in half. This is the result. So if the government still, and we have 395,000 is kind of the range that they're looking at trying to hit for the purposes of overall numbers. And if we go down to the economic immigration total of 232,150, which encompasses all of these areas, they're still going to be issuing invitations to apply. And so on the economic front, the numbers are still fairly healthy on the economic front. But when we look through here, we can see that there's definitely, they have not been issuing as many Canadian Experience class as of February. We've been over a month without a CEC draw. And they've done a couple French, which I'll leave that as it is. But I think I would expect like this week or next that we're going to have a CEC. I would be surprised if we don't. So I guess we'll have to just monitor that. And those of you who are sitting in the round of invitation pool, and actually let's bring that up just quickly as well here. I'm just going to backtrack and I'm going to go to the score distribution. So as of 3 days ago, March the 16th, you can see that the scores of individuals at the 600 plus, there just really isn't a lot in there. And so some of these are still individuals. Like people say, well, how do you get over 600 if you're not a PNP nominee? Well, you get that high as a result of potentially French, if you have a really high human capital to start with, and job offers, which have not yet been pulled. And some job offers, if for executives, are 200 points. So that's where you get CRS scores that are up above 600, but not all of these were drawn. And if we go back, you can see 536 were PNP. And so some of them were individuals that just had really high human capital. So if we go back through here, and once again, we look at the other category, this is the one that is the big glut that everybody is looking at. And Alicia, I'm gonna pull up. We've got a new minister here, so I'm gonna pull up our new minister, and I'm gonna kindly ask you, minister, to instruct your department to break this 501 to 600 range down like you do for the 451s to 500, because people want to see in these brackets of 10, as these increments go up, they want to see how many people are in the range of 501 to, well, really, just like we have structured here, 501 to 510, 511 to 520. They want to see that breakdown. I would assume, Alicia, that the vast majority of these people that are in this category at this 25,000, that the vast majority of them are between 500 and 530. I think that's kind of what we could expect. So I know there's going to be a question from people that are watching. And if we have another round of invitations, what do you think the CRS score will be? And before we do that, we'll pull off the minister. We'll come back here and we'll bring up our crystal ball. What do you think? Oh, I'm with you here. I've got this. There we go. It's the moving crystal ball to line up better. So what do you think the CRS score would be for CECs? And I guess I'll qualify one thing. We'll leave the crystal ball here. I'll qualify one thing. If we see that the rounds of invitations are, and if they choose to issue the same level, the same number, which we had, we'll shrink this down here. Whoops. I'm all over the place here. Back here. They've changed how these things are structured. If we say that they do another 4,000, we'll say, because they've done 4,000, 4,000. If they were to do a 4,000 CEC, what do you think the CRS score is? And let's see, because if they do it, I want to see how close Alicia can actually get, because it depends on how many they do. But if they do 4,000, what do you think? What do you
All
think?
right, I'm going to guess. I'm going to go with a 530. I'm going to go with a 530.
Okay. I think you're exactly on the right track. So I'll go with 531 just so that I can cut you off, and anything higher than that, I'll win. But I think because of the time that's passed here, and individuals every day are hitting their second year of work experience, they're getting additional points. Maybe they've been studying French, all those things come into play. And so when we have a little bit of a gap, which is about a month and a half here, we always expect the scores to go backwards up to this level again. And you can say, even from here, when they did 1350, that's part of the reason that the scores stayed high here. But then, with only a couple of weeks, they did another big one, 527, and then another big one, which dropped it down 6 points into this area. But I think it's going to be a long time still before it drops down to the level of 510, which many people have been very, very interested in trying to get down to that level. So
unless they take away the 50 points for job offers.
Exactly. Okay, let's see here. I think we've got Monty. We'll give a shout out to Monty here. Let's dive in and get to some of these questions. Okay, we'll try this one and. Okay, in PR applications, to be inadmissible on security grounds, do you have to be proven to have committed certain acts, or is estimate based on your overall profile that you may commit such acts in the future enough? This one, this is so this is different than background checks, guys. This is the security. And Alicia, what are your thoughts on that?
So inadmissible on security is specifically under the Act. So I believe it's section 34, 35, which one is it? Where there is very specific legislation, and then there is a giant body of case law that is going to talk about that legislation. And so, I don't know, Mark, if you can pull up section 30, I think it's 34 or 35.
So this is the division on inadmissibility, and then it all kicks in here, security 34. And there's a bunch of different grounds of inadmissibility. Security is 34.
Exactly. And so this is where specifically it matters what CBSA and IRCC are alleging. So what specific subcategory of grounds of security are they looking at? So is it, engaging in espionage? Is it being part of a group? Is it doing an act of violence? Is it, so the most complicated one is Section 34, sub 1, sub F, which is being a member of an organization that there are reasonable grounds to believe engages, has engaged, or will engage in acts referred to all of the above.
Yeah.
And this one, there's been a lot of case law on,
Yeah. A
for
lot of
sure.
litigation.
And this is a moving target in terms of what the judicial interpretation is. And so it is a super complex area of law. And this is something where I'd say if there is an allegation of a security risk, that and then go speak to a lawyer who deals regularly with
Yes.
security cases for inadmissibility, because this is highly complex, and it's a difficult area of law that usually requires litigation.
Yeah. Yeah. Yes. This is an area that you definitely are not going to want to wield on your own without legal representation. Um,
Yeah.
and this 34, this is just the grounds for security. There are other inadmissible grounds as well that kind of are kind of fit within this same family of inadmissibility. Human or international rights violations. Um, that's a big one. And then the criminality sections in section 36, those are the ones that where you're found inadmissible because you have a DUI in Texas, right? That's that and you have not obtained rehabilitation for that. So serious criminality there. And transborder criminality, we keep zipping through here. Organized crime. So this is section 37. So you can see, and then we get to the health grounds, where if you're, medically, you can be found inadmissible if you're likely to be a danger to the public, to public health, or to public safety, or might reasonably be expected to cause excessive demand on health or social services. So these are all the various grounds of inadmissibility, generally speaking, that people can, be barred from permanent residence. All right, let's zip down here. We'll go to the next one. We do have a super that came in. So Adnan says, hello guys, could you please go over the process of PR after nomination, non-express entry based on my rural renewal PNP, i.e. timeline, what to do while waiting for the AOR. Okay, so Adnan, as you've identified, when you get nominations through the provinces, some are connected via express entry and some are through a non-express entry stream. And when you get your nomination for a non-express entry, you're not submitting your application through the express entry portal, the IRCC Secure account. You're going through the PR portal. And so, Alicia, do you want to just briefly address kind of how that process works for someone who will assume Adnan has their nomination?
Yeah, and so one of the things that I was just trying to pull up here too was our AAIP. So if it was under the rural renewal in Alberta, I'm assuming, they literally have a page. If you go back to the AAIP, and it's Alberta Express Entry Stream after you are nominated. And so there's a lot of helpful information in there. But the big thing is, how long is that application going to take for permanent residency, and what is your status in the meantime, and when does it expire? And I was just recently, this week, helping another applicant who was in a really sticky situation. They, again, had a non express entry linked PNP nomination. And I feel so bad for this person. Like, honestly, he was trying to do his best. He graduated with a master's degree, it was an engineering master's. Like, this is no um, slouchy course. This is something that's really difficult and intellectually rigorous. It was a full master's program. And for whatever reason, he only got a 1-year PGWP on a master's. And so he was hustling. He got his nomination. He submitted his PR portal application back in September. So submitted a full PR portal application after nomination in September. And the difficult thing was that his work permit was expiring. And so he submitted an application to change conditions. He said, look, I submitted everything. I don't have my AOR, but I have all the proof that I submitted my PR application through the portal. And 6 months go by. 6 months go by, and guess what? IRCC refuses that work permit, the bridging work permit application, and literally 7 days later, he gets the AOR. And so now he's got to do a restoration application and a new bridging work permit. He's got to stop working because he can't work as soon as he's got that refusal. And so this is a real issue for a lot of people, that because the processing times are so long on these PR portal non-express entry linked applications, it means that you've got to be really careful about your work permit status in the meantime if you're inside of Canada. And so take a look. Go back, I wrote a whole article on bridging open work permits versus bridging closed work permits. So depending on your category, take a look at on your nomination certificate whether it says there is a restriction on employment. If there is a restriction on employment, then be really careful that you are applying for the correct bridging work permit. Sometimes you actually have to go get a bridging closed work permit, which means that you need a letter from, it means that you need your employer to do the employer portal offer and submit that. If you're doing a bridging open work permit, you need that letter, the R204C letter from the province, before you can submit that bridging work permit application. So make sure that you are not losing your status if you've got a work permit coming up for expiry soon.
All right, let's tackle this one from Info. That's quite the handle. An employee working for a Winnipeg, Manitoba-based employer in the IT industry, but residing in Ontario. Aha. Due to the remote nature of their position, apply for the Manitoba PNP skilled worker stream for PR. So I think the question is, can an employee working? And one thing we can confirm in every situation, I'm not aware of a single province that would issue a nomination for someone to their province who's not actually living there. And I think that's a general prerequisite for every province. Maybe I'm wrong, Alicia, but I can't see any province whose underlying mandate is to ensure that you have the ability to economically establish in that province would issue a nomination for someone who is a remote employee working for a local based employer in that province, but living in another province. I don't know if you have any thoughts on that, Alicia, but I can't see any world where that would happen.
Yeah, and so that's where, Manitoba has two skilled worker streams, right? They have the Manitoba skilled worker in Manitoba and the Manitoba skilled worker overseas. So maybe if you were trying to do it in the overseas category, even though you're living in a different province in Canada. But yeah, take a look at the inventory too, because many of the provinces are saying they're not taking new applications because they're hitting inventory targets already.
And I guess I'm glad you brought that up, Alicia. So have we had clients in the past who lived in one province and received a nomination or an invitation to apply, through an expression of interest system? Yes, we have. Like, I've had individuals who've received those expressions of interest even when they lived in a different province. But the reality is that you have to demonstrate very clearly that you have an intention of living in that province once your permanent resident application is approved, if it's a PNP, nominated application. And so, the expressions of interest I've seen come, but people really have to show, especially Manitoba, of any province out there, they have really, really refined their parameters and the criteria they're looking at to find the candidates that they have the greatest belief will actually stay. And they're as refined as any province. And in fact, if you are living outside of the province, or you have any contact with, or have had any experience living in Canada in another province, you're losing 200 points right off the bat. So they really, really reduce the likelihood of you getting that nomination in the beginning. All right. Diane says, hi, Mark and Alicia. Does the Francophone Mobility Work Permit also cover the work permit of the spouse, or they need to apply separate work permit? How many years work permit validity can we expect? So I'm going to tackle that one, Alicia.
No, yes, it depends. So the Francophone Mobility Work Permit is only for the primary applicant. And so the primary applicant has to meet that NCLC level 5 in a French test, TCF or TEF, speaking, reading, listening, and writing. It has to be 5 across the board. Then the person's employer, the employment has to be outside of the province of Quebec, would submit that employer portal offer. And it depends, because that employer portal offer is going to list the length of time that the company is offering that employment for. So they might issue it for a specific term. It might be 1 year, it might be 2 years. Maybe they could ask for 3 years. They have to justify it. But presumably you would also have to renew your language test score to make sure, because those language tests are only valid for 2 years. So the principal applicant might be able to qualify, but whether or Whether the spouse of the principal applicant is going to qualify depends on whether the spouse can separately qualify for a type of work permit. Maybe the spouse can qualify for a francophone work permit if both of you are francophone, but if not, then you get into this whole complex situation of open spousal work permits for spouses of high skilled workers. And this is where, go back to Igor did a really good job on his blog article on our website, holthelaw.com, that talks about who can apply for that open spousal work permit. And most people, if you're not working in a tier 0 or 1 job, there are only specific occupations for tier 2 and tier 3 that will qualify. And the principal applicant's work permit has to be valid for more than 16 months. And so if the principal applicant's looking at doing a francophone mobility, try to get that job offer for at least 16 months so that the work permit's going to be issued for at least 16 months, so that hopefully the spouse, as long as you're in one of these tier occupations, tier 2 or tier 3 occupations that are listed here, that the eligible are eligible, hopefully maybe that spouse can qualify. But there's a lot of moving parts here, so it's not an automatic thing.
Yeah. And one thing I really like about Igor's blog post is we know that 0 and 1 tier occupations, your spouse is eligible for it. When it comes to tier 2 and 3, it really comes down to the occupation in specific sectors. So what Igor did was he actually produced the list here. So you can go through and you can see if your NOC code is on the list. And this is the occupation of the principal spouse. So this is the one that's on the postgrad work permit. If they can show that their work, that the offer that they have is in one of these occupations, then the accompanying spouse may be able to apply for a spousal open work permit, bearing those other factors that Alicia talked about, the duration and things like that of the work permit itself. But yeah, anything related to this is a great blog post. And once again, on our website, you can just click speak to a lawyer if you have any questions, and we can navigate our way through here.
And just to clarify what Mark said there, it doesn't have to be a PGWP. That principal applicant could be on a francophone mobility or a different type of work permit.
Yeah. Okay, let's go to our next super chat. This one's from Monty. He says, hello, I'm a Canadian citizen living in the US on a business visa with my wife. She is pending her asylum claim here in the US from Asia. Can I sponsor her to Canada while we're both in the US? So the short answer, Monty, is that yes, you may be able to sponsor her. You as a Canadian citizen have the ability to do that, even though you may not be currently living in Canada. But in the process of doing so, you need to very clearly set out your intention to return to Canada the moment the application is approved. And this is the one big difference when it comes to permanent residence versus temporary residence when you're applying for Canada. So when you are applying for permanent residence, the big issue is that, well, I should say for temporary residence, the big concern is that immigration will be very unlikely to approve any temporary document. Let's say you wanted to bring her as a visitor to Canada, and you said, okay, well, we're married, and I want to be able to have her come visit my family in Canada. Well, it's very likely that the immigration department is going to refuse that for a lack of temporary intent. If you have shown that you've come to the US and then applied for an asylum claim, they're going to be very, very reluctant to then approve a temporary application in Canada because they'll feel, well, at least that there's evidence to suggest that she might make a refugee claim in Canada. But when it comes to permanent residence, the good thing about that is that those factors really don't apply. So it is possible. And Monty, I'd encourage you to book a consult and we can help you to navigate through this process. It's interesting, Alicia, over the last little while, spousal sponsorships have become way more complicated than they were in the past. Immigration with their one-touch policy has really made it challenging. On the surface, it looks like it's all good and that there's no issues. But I had one client on the spousal side. We filed the online application. And in the course of doing so, I'm not sure exactly how it happened, but they had two unaccompanied children, non-accompanying children. The one partner had with a previous relationship, a previous marriage, and we had included everything that we thought was necessary for them, but we did not include the birth certificates for the kids, and they were non-accompanying; they weren't coming, and they returned the application. Fortunately for us, it did not take them too long to get it turned back, and we were able to resubmit it the very next day. But there's no mercy in these applications now. It's not just express entry, which was the very first application to really adopt this completeness check philosophy. And then it was slowly rolled out to pretty much all of the other permanent resident programs. But yeah, it's a volatile world. So yes, it's possible to sponsor. If you do it correctly, you do it properly, then you might be able to do that, Monty. And if you need any assistance, I recommend you book a consult, and we can at least kind of point you in the right direction. All right. We've got another super that's dropped in here from Peter. He says, for the home care worker immigration pilot, okay, we'll qualify, both Alicia and I. This is not, we don't do a lot of home care worker applications. So let's see what we can do for Peter here. For the home care worker immigration pilot, is one required to do an ECA for an internationally trained caregiving credential, even though it might not be the highest educational credential one has? And I don't know, Alicia, if you've got any thoughts on that. This is, Peter, this is an area that we don't focus on within our firm. We don't do a lot of these types of applications. And so, yeah, we'll maybe what we'll do here, I'm going to take a screenshot of your question here, Peter, and I am going to take this and I'm going to pull it up next week, and I'll have an answer for you next week. I think that's the best, safest way to deal with that one. I recognize you put in a super here, so I want to make sure you get your value here. So so Peter, will come back and I'll I'll save this one and I'll pull it up next week, and we'll get an answer for you on that one. It's obviously just changed. There's a new program, new parameters, new rules, and it's still really, really fresh. So we want to make sure that we go back to the source and see if there's clarification. Usually I find you guys ask these questions because it's not clear. So we will see. And we do have a few channels to get some information too, that we can rely upon. Okay, let's see. Next here, this is from Sam. And Sam says, my friend, he applied for PR and is waiting for a decision. Applying for a bridging open work permit. So on the 5710, it asks, have you been issued a provincial certificate? Should he, so he applied for PR. It doesn't say if it's PNP. Okay, it asks, have you been issued a provincial certificate? Should he select yes, as he nominated by province, or select no? So, yeah.
So Sam, this all depends on the timing. So, and the documents. So if your friend applied for PR and they're waiting for a decision on nomination from a province, then the answer is no, because they don't have the nomination certificate yet. However, if your friend applied and does have a nomination certificate, so literally they have something back from the province that says, yes, you were nominated. It should basically have a little table on the top with a nomination certificate, the certificate number, the validity date for that nomination, the category under which they're nominated, whether there are employment restrictions. So if your friend actually has a nomination certificate that is valid, then the answer on the 5710 would be yes, there is a valid nomination. And then it's up to your friend to explain that in the LOE in terms of whether they submitted that PR application, whether it was express entry linked or whether it was through the PR portal. But really the thing is there a valid nomination certificate? Yes or no? And he would literally have a piece of paper with a validity date and a certificate number.
Perfect. All right, let's go to our next question. This one is from Prem. He says, hey, Mark, any update on tier 4 and 5 PR pathways? Okay, this is fantastic. It's a great lead in. So about, I don't know, was it 2 months ago? I can't remember. Maybe it was 2 months ago, maybe a little bit longer. Someone said, when are they going to release the new category specific draws for education? And I said, oh my goodness, like, why in the world would they do that? That is not going to happen. That's what I said. Okay. And then lo and behold, what do we have now? We've got a category for education, which is, it still just boggles my mind how that category arose. I'm assuming maybe there is a need for teachers, but every school division that I'm aware of, maybe they do have some exceptions for foreign nationals as teachers, but generally speaking, those positions are reserved for permanent residents. I know in Alberta, there's a lot of young teachers that don't have jobs and that have temporary contracts. And there's a strike looming in Alberta for our teachers. And so I just found it was quite interesting. But what I'm getting at here is this question here, tier 4 and 5 PR pathway. My gut tells me there's not a fat chance that that's going to happen. But what just happened here just a few weeks ago? Well, it was our out of status construction workers. And I see I've got just about 4,000 views. You guys, you have to watch this video. In this video, I shared two really fun, well, not fun stories, two really heartfelt stories in there about my experience in Portugal. One was my experience in Portugal when I was serving my mission there and spending a lot of time with construction workers that were undocumented. And, you know, then they might have been legal actually in Portugal now that I think about it, but they're from Africa. And so this is all about the out of status program that Minister Miller announced, kind of his last hurrah before he drifted off into the sunset. And I just could not see it. I just don't get it. When you're trying to get 2 million people out of the country, and then you're going to actually incentivize people to fall out of status. Now, we don't know full details on this yet. We know that the previous program for the undocumented construction workers required them to be, I think, Alicia, out of status for 5 years or more before they were eligible to participate. So are we encouraging individuals who don't have other options to just not worry about extending their permit and reward also the construction companies that are employing people illegally? Like, I don't understand this. And then there was a really cool part of that. I had someone who was actually a construction worker, recent permanent resident in the Greater Toronto area that was currently out of work. And so it was quite interesting to have him on. And there were some other people that said, oh no, you just have to come to this area. We're always looking, you know, there's always a shortage. But it was as much about the permits and the ability to build the house as it was, that was the problem with the slow, you know, building of homes. It was more the licensing as it was, you know, people to actually build the houses. So anyways, so a very long way to circle around to the fact that I don't know. I would be utterly shocked if there was a tier 4 or 5 PR pathway, but we have seen others in the past.
Well, okay, so I'm going to qualify that because we do have the Francophone community rural pathway and we do have the rural community immigration pathway. So those do cover tier 4 and tier 5. So Prem, if you mean a completely brand new category just for tier 4 and tier 5, I'm with Mark. I think it would be highly unlikely. Again, we were wrong when we said we didn't think there'd be education. But we're trying to analyze logically based on where immigration has said they were going. And so do keep in mind that this is a bouncing ball.
Sometimes the crystal ball, it betrays us.
But to be fair, they did implement the rural community immigration pathway and then the Francophone community rural immigration pathway as well. So both of those, you can have work experience within the last 3 years that was in tier 4 or tier 5, but you do need a job offer, and it matters what level and what knock your job offer is going to be in, and whether you've got ties to that community and whether that you can get a community endorsement letter.
Yeah. All right. I've got a series here. I wasn't going to pull up your questions, John, but I think it actually is worth doing it because it kind of fits part and parcel to Alicia and my podcast episode. So if you guys have not yet subscribed to the Canadian Immigration Podcast, you're commuting, you're traveling around. It's a perfect way to listen, get educated while you're on the move. Our latest episode, we actually have, I wonder if it's dropped yet. Let's just see here. Okay, 163 is going to be dropped, and it's on reference letters within our Express Entry Getting It Right series. But definitely, you want to take a look at and get caught up on all of the and on all of these videos, and they're all on the YouTube channel as well. But our podcasts that cover a whole host of areas. We've started this new series called Express Entry Getting It Right. You can see here, show me the money, funds, category-based draws, police clearances. We did do one on police clearances. That's right. We did a recording this morning. I couldn't remember if we'd done one on police clearances. It's all a blur, you guys. So the Express Entry Getting It Right series. But before that, it was loaded with our Time's Up series. And I've got my little dog. He wants to turn my audio off here. The Time's Up series has a bunch of topics that are all designed to give you information on how to navigate your way out of everything that's happening here. One of the things that we are really, really keenly focusing on right now is this world of inconsistencies within applications. And John says here, hey, Mark, nowadays I've heard that more PFLs, procedural fairness letters, are being sent for people who are fit for category-based draw, not codes, but do not have related education or training or license, for example, a certain knock. And he goes on to say, can one do a job without having education in, say, healthcare sector? And then what are the chances of getting a PFL or denial for these reasons? And so the big issue that we're dealing with here is people now who look at the category-based draws and they say, hey, I just need 6 months of work experience in one of those new categories in order to qualify through one of the draws where maybe the CRS scores are lower, right? And so people are now looking at every opportunity they can to shift over and try to use whatever mechanism to increase their chances of getting permanent residence. And our current draws, as of recently announced, French is on the list, but the occupation ones, healthcare, science, are STEM, which really STEM is more like SEM. There is one kind of tech draw in there, but most of the tech has been stripped away. Trade occupations, ag and agri-food, which they're really, really, a lot of these have been stripped away. And then education has magically popped up. And Igor and I did a live a video on this exact topic. I'd encourage you to go take a look at our YouTube channel, and you can see all of the different topics that we have that we've done in the past. But yeah, Igor and I, new express entry categories. That was 2 weeks ago. We did that one. So go and pay attention to our thoughts on those rounds, those new category based draws. But ultimately, as if we can find it, ultimately the question becomes for healthcare. And if we look at the eligibility requirements, let's just go down here and we'll just go straight to health and social services occupations. When you check on that, it says that you've accumulated within the past 3 years at least 6 months of full-time continuous work experience or an equal amount of part-time, which basically means 1 year of work experience that's less than 30 hours and kind of more than 15 in a single occupation listed in the table below in Canada or abroad, and meet all the requirements to the instructions for that round, which, you know, is all based on CRS score and wherever they choose to set the pass mark. But on this list, and I think if I'm not mistaken, John had given the exact knock code, and I don't want to take the whole time going through it, but it looks like it's knock
state orderlies
33103. Okay.
Oh,
So
okay.
we can, yeah, so we can go here 33103. And so this is pharmacy tech assistant and pharmacy assistants. So the question becomes, and this is where people are running into issues. So let's just go knock 2021. We'll pull this up. Let's try here. Is it this one? Big money. Yeah, this is the one. Okay. So then if we go to the knock code, and then we'll just punch in the knock, pull up this knock code. So here's the issue. And we'll just pull John's comment off of here. When you're going through this process, we have certain things that we know are mandatory to claim work history, that you've performed the activities in the lead statement, and a substantial number of the main duties. And when you're looking at the federal skilled worker program, for instance, it specifically states that the employment requirements are not to be taken into consideration when you are determining whether or not the person has the respective foreign work experience. But CEC is silent kind of on this, and claiming work experience in Canada in order to perform an actual position, employment requirements do play a little bit of a role, especially if it's in a regulated trade or regulated occupation where you need to have specific licensing in order to perform the job. So if we take a look at this, you can see pharmacy tech assistants usually require completion of up to 2 years of pharmacy tech assistant vocational program. Pharmacy assistants usually require completion of a pharmacy assistant college program ranging from this. So from this standpoint, even if the employment requirements for that occupation were somehow mandatory, which That is not generally the case. Whenever it says usually required means in and of itself that these things may be good to have, but they don't bar you from being able to work in that occupation if you have if you otherwise are performing the duties. So immigration, when they see a ton of people just submitting applications where, and this is one of the big things I see, Alicia, where someone has classified one of their occupations and registered it within the express entry profile as one thing, as one not code, and then come back and say, well, no, actually, I think it's 33103 instead of a different not code that's not otherwise on this list, right? So that's really where it comes down to is go 3.3, got so many going on here. Let's even go to the back here. Yeah, I don't even know if there's a similar occupation that we can use, but really something that's similar. When people start to change, that's when for sure you're going to trigger a procedural fairness letters. If IRCC comes back and says, no, we don't believe you did the job, but you've provided a reference letter from the company, you've provided, the pay slips, pay stubs, your T4s, you've provided everything that you need to prove that you've got that work experience in Canada. And for this occupation, let's say they come back and say, well, you don't have a technical assistance program. I personally think you could challenge that if it was a refusal. So that's my belief. But a blanket response, John, to your question is not something that Alicia and I can say. So we can't just say, yep, it's a clear no or a clear yes, other than saying it's a factor that officers can look at and that it can be used to inform whether or not they believe you actually perform those duties or something else. And they do have discretion, but they can't ignore the law either. So if you have not provided a good reference letter, your duties are kind of shaky, then they don't have to agree with you. And that's part of the reason in our express entry masterclass, this one right here, this is why I have a specific lesson in here on drafting work records of employment for proving work history. And one of the things we have in here is our little Knox selection tool template that we have every one of our clients complete, and everyone who goes through the course, I encourage them to complete and upload, which shows very clearly to the officer that you've chosen the right knock code. And then a bunch of other steps that we basically encourage our clients to take to further shore up and strengthen the work experience that you're claiming. But in short, it's not something we can't say 100% yes or no, John, but those are the factors an officer looks at. All right, we'll hit a couple more here and then we'll wrap it up today. Okay, let's see. So AC in CA also has got a super chat here. Hi, Mark and Alicia. Oh, it's a trend. It's trending now, M&A. Finished, it should be A&M actually. You go for quality first and then, it's like substance and then form, right? Although probably Alicia has both the substance and the form, and I'm just kind of the videographer. Okay, finished ECE, so early childhood education. Been working in childcare, stopped upon receipt of the postgrad that states not authorized to work in childcare. How can this be resolved? Received medical request same day of approval. Interesting. So looks like they're already down the path. And yes, and this is something that comes up a lot, Alicia, because people who are on postgrad work permits often, when they apply for them, they don't get a postgrad that is, that has the medical clearance that without restrictions. And so this happens a lot. And so AC, I'm glad you asked this question actually, because it's a really good one.
Yeah, so there's actually, if you go to IRCC's webpage and you talk about how to remove medical conditions from my work permit. So if you search up, how do I remove medical conditions from my work permit and IRCC, basically it's telling you that hopefully, ideally, you would have known about this in advance and you would have gone and done an upfront immigration medical and you would have had that completed so that when you applied for your PGWP in the very beginning, they would have already had you pass the immigration medical and then you wouldn't have those medical condition restrictions on your employment when you got your PGWP back. Unfortunately, if you hadn't done that upfront medical, you should do so now. So hopefully you've completed it. If they sent you that medical request, you have completed it. And then you can update with a web form just to make sure that, yep, I did upload my medical conditions to my IRCC account. Here's proof that it was completed. You've got that medical information form with the little barcode and your photo that you can upload, and you'll have to do a change of conditions application. So you're going to need to submit your 5710 and do an application for change of conditions on your work permit, and say that you are specifically requesting that those conditions be removed once you can prove that you have a valid immigration medical, you have all your vaccinations, you don't have communicable diseases, and you're not going to be at risk or a risk for at-risk populations.
Yeah, that's a great question, AC. Great question, and super super awesome tip here on how to do this, Alicia. Okay, last one we'll got here is Hosh. Hosh says, "Hi, Mark and Alicia. My employer raised my pay permanently to cover 3 weeks unpaid work, exceeding the owed amount. Will this affect my FSW continuity?" Federal Skilled Worker. I wonder if it's the Foreign Worker Program. Is this an LMIA? This is one of the challenges that we run into, Hosh, when we're
Mhm.
trying to answer specific questions where you say, my. That's why I ring the triangle and I say slide over and book a consult. And always, guys, the links are in the description for how to book a consult with us, the Express Entry course, everything that you need. You can find the podcast links. Everything are in the description. But this is a challenging one for Hosh because if you're on a foreign worker, like if you're a foreign worker in Canada on an LMIA based work permit, increases in wage or bonuses or things like that that are not previously contemplated within the terms of the employment that was actually included in the application for the LMIA can be seen as non-compliance. But as
Are-
far as raising
I,
pay, yeah,
I
go ahead,
think what
Alicia.
Hoff is saying is it's federal skilled work outside Canada, and they're trying to get their 1 year continuous.
Oh,
And they
unpaid.
had 3 weeks of unpaid work. The employer is
Mm,
then bumping up their salary to try to say, hey, we
that they
paid
were
you
working
for
during
those
that
three
period.
weeks.
Ah,
That's what I'm thinking.
I'm going no there, Hosh. Because at the end of the day, you have to work. It's not just being paid. You actually have to be performing the duties. And we
Yeah.
run into this a lot. Now, with that being said, there is vacation entitlement and things like that. And if people are on paid vacation, right? If they're on paid vacation and you're not working because those are regularly scheduled holidays, and people in Canada are entitled to paid vacation, and I would say up to 3 weeks even is fine. Once you hit into a month, if your employment agreement talks about 4 weeks of paid vacation, I guess you could still claim that for sure. But that's really what it comes down to. So, but unpaid work, then trying to go back retroactively to cure that, I think you expose yourself to some misrepresentation findings. That's how I feel. Alicia, your thoughts on that one?
Yeah, I'd be worried if after the fact they're trying to bump it up to say that they did pay you for those 3 weeks that were originally unpaid. Um, you want to make sure that you are for sure hitting eligibility, which is at least 1 year continuous 52 weeks of work within the last 2 years. So,
Mhm.
and
Here's a
Mark, I
great
just
question.
had,
Oh, yeah, go
oh,
ahead, Alicia.
I just wanted to say quickly too, I saw a couple comments from MD Wadur Raman who said, I've got a CRS of over 500 and I don't have LMIA points, but I'm thinking of going undocumented. Please,
Oh,
please,
yes,
please reach
yes.
out and
Yeah,
book a consultation
yeah.
because,
Before you do
and
that.
take a look at our Time's Up
Yeah,
series because
yeah. So you can see
all
right
like you
here.
never want to go
Mhm.
undocumented.
Never.
It's a
Mm,
breach of the law. And so there, especially if you have CRS of over 500, there are so many other options for you if you can just wait it out. So
yeah.
please, please, please book a consult.
Yeah. And I'll just point out once again, subscribe to our podcast if you have not yet done it. We have, corresponding videos for many of these, but our Time's Up series was specifically created for you guys. So please, and MD right here, the high cost of staying in Canada legally, please review this and watch it on our YouTube channel. We also have, and I put that link in just so that you guys know for the how to change conditions on the work permit. But um, let's see here. I can't remember if we did a video for that one, Alicia, or if it was just, I don't think so. Oh, there it is. Yeah. So here's, even on the YouTube channel, you can watch Alicia and my podcast, the within the Time's Up series, The High Cost of Staying in Canada Illegally. So yeah, whatever you do, please book a consult and let's talk you through this, because it's not something we would ever encourage anyone to do. Okay, Amkulel says, hello, it's Elaine. New here, welcome. Tuning in from Ottawa. Have a big reconsideration case against IRCC. How can an immigration lawyer assist me? I believe I have strong grounds. Can I file complaints? Okay, so if you go to our website, and I'll just shift back here. So we got, and you go to our website and you go to our permanent residence, temporary residence, refusals and delays. This page right here, our refusals and delays page, we have a bunch of explanations on the various services that we offer. Judicial reviews are one of those options. Reconsideration requests are things that we do. And we talk at length about how we work with people through the reconsideration process. And also, when we cover our judicial reviews, we talk about this option that's sometimes available. And but when it comes to your situation, how we can help, well, ultimately, one of the things we do more than anything else is to determine if the mistake was yours or it was immigration's, because there's a big difference between that. If you made a mistake, well, there's not much that you can do. Reconsideration, you can't reconsider a correct refusal, and you're not going to file a leave application to judicially review a decision that was correct in law. However, if the error was on the side of immigration and you've got a strong case, absolutely reconsideration is a possibility. But or even judicial review, but timelines are really tight, Elaine. And you only have a very, very narrow window of 15 days if you are in Canada, if your decision was made in Canada, to start the leave application process. So there's no delay. So, as always, we recommend that you book a consult, and then we can go through and help you to understand what your legal rights are and the possibilities. Yeah. All right. I think we are... let's see. Gia says, is it okay legal to apply? Oh, okay. We'll finish with this one. All right. So this is another one that we are seeing so frequently. So the question is it okay or legal to apply for a post-grad work permit extension? So to start with, there's no such thing. Okay. In the past, Minister Mendicino and Minister Fraser had instituted these 18-month post-grad work permits under humanitarian Section 25 to allow people to apply for them, but they weren't technically an extension of a post-grad work permit. So for post-grad extensions, the question is, even though it will be refused eventually because post-grad work permits are not extendable. Thank you. Just to get an implied status for a month or two. So Alicia, I'll let you tackle that one. I've got my own views on this, but what are your thoughts on people who are just doing it when they know they're not going to get an approval? They're just filing an application.
Yeah, and first of all, that's a really cute baby. But second of all, you always have to be honest. And so if it is possible for you to submit an application that is 100% true and accurate, then maybe, right? Like maybe you have an LMIA in process with a employer who's been waiting for that labor market impact assessment to come through, and you're filing this work permit kind of as a last ditch effort to try to bridge you to get that LMIA approved so that you can get that work permit under the LMIA. Sometimes that happens. Sometimes you actually have an employer and they're in the process of doing that employer portal application, and maybe you can try to go to that. As a lawyer, it would be unethical for me to submit an application that I know has no basis in law. So I can't do that. If you have some valid basis in law to make the request that you're making and you don't have any other options, it might be possible for you to do that, but you have to be super careful about misrep.
Okay, I was just going through while you were talking there. We just have two more I'll just hit really quick that are right in line with Express Entry, and they really fit nicely with our Express Entry Getting It Right series. I think those of you who have been watching us for quite a while know, and I'll just reiterate for those that have just jumped on late, if we go to our list here of videos, you'll see that we have a series of Express Entry Getting It Right, basically, as well as our Timed Up series. And these are some of the questions that we get, and these ones I'm going to pull up right now, like Joe. He says, do I need to disclose my Canadian daughter on my express entry application? She was born when I was still a student. And then he says, loving the Express Entry Accelerator, best purchase. Thanks, Joe. So Alicia, it's a pretty simple answer, but people, it's fair because they're like, well, what's the point? They're already a Canadian citizen, right? But once again, the exposure to misrepresentation is very real. So what are your thoughts, Alicia, on Joe's question?
Yeah, you always need to disclose your family members, right? So it doesn't mean that you're including your Canadian citizen child in your PR application, because you can't, because your daughter's already a Canadian citizen, but you still need to disclose the fact that she is your child. And so normally, at very least, that involves providing a birth certificate for your daughter. And it might have implications or questions about, well, who's the mom? Was the mom included in your application? Was this from a previous relationship? Did you declare a previous relationship? Were you common law spouses? Were you not qualified as common law spouses in the past? So sometimes these things open up a little bit of a can of worms that you need to deal with. But for sure, if you have a Canadian child, so anybody who qualifies as a direct family member needs to be disclosed in your application.
Yes. All right, last one for sure. The very, very last one. Sarita says, is there a problem if my pay slips, another little cute pet, man, you guys, the things you choose to put as your little your little handles here on YouTube. Is there a problem if my pay slips don't match the salary I receive in my bank account? It's for PR application through Express Entry. Well, this maybe it may very well be a problem. So what we don't know is why do they not match? Is it a case of you getting a bonus that isn't a part of your regular salary, and that's kind of affected your overall salary for that year? It really comes down to why. And these are the exact things, Sarita, that and I'm just going to slide over here. Like this is what we cover in the course, the importance of ensuring consistency. If you go, this is exactly what you see when you subscribe to the Express Entry Accelerator. So if you click on, you'll have access like this. It'll show view the course. And then we have a bunch of lessons. And as we go through here, there's over 70 individual lessons that walk you through the whole process of Express Entry. But I just want to swing down here just to remind everyone, the Mastering Your Documents section, when it comes to records of employment, there is just a plethora of resources to help you make sure you're not making these mistakes. You can see all of the sample reference letters we have here, which are all there just to show you that it's not the form of the letter, but the substance. We have an instruction sheet you can give your employers. We've got record of employment checklist, all the essential components that you need. And when it comes to, your question, I also provide a very detailed explanation of the additional documents that I like to include when I'm submitting my work history and evidence to support the work history. There's also, with every lesson, a video. This one's like 25 minutes, just teaching everything that we know about the records of employment and proving your work history. But when we look specifically at your situation, Sarita, it's not just pay slips and your reference letter. It's the information you put into the work history in your profile, in your EAPR. It's the title of your occupation. It's the employer name that you list. And all of these things can be issues when you're saying one thing in your profile and then you're saying something else in your EAPR. And this is a wonderful segue to episode 164 of the Canadian Immigration Podcast that Alicia and I recorded just before we went live here. And that podcast covers all of the things you need to know and understand when you're making a change from the information you put in your Express Entry profile to what you put into your EAPR after getting an ITA. And, the biggest issue is if an officer sees a salary listed and they then see pay slips that don't align with it, well, they're instantly going to start to think, okay, well, is there a mistake here? Is there an error? Or is there some form of misrepresentation? And your job is to get it right. Your job is to make sure that everything is true, complete, and correct. And where that is where you're struggling because there's an inconsistency in your application in any way, then I shift back to our course here, and I have a specific lesson on page 2. There's so many that I needed 2 separate pages that covers letters of explanation in detail and the things that you need to do to think about when you're preparing a letter of explanation that's going to address or at least try to explain to an officer why there is this inconsistency. And those LOEs are really the secret sauce to defending and shielding you from a finding of misrepresentation or an allegation of such. Anything else to add to that one, Alicia?
No, I mean, it is an important issue. And if it is Canadian work, then they want you to include your T4 statements. And sometimes people have differences in their pay stubs versus timesheets, and sometimes there are deductions, right? So Canada has various EI, CPP, there's different types of government deductions for taxes that sometimes happens, which affect the pay stubs. And it might be something as easy as that, where you can just explain it based on, these are mandatory deductions or union dues or various things. But if there is a real change and your employer might not have been paying you properly, it's something you're going to want to look into and figure out how to address.
Yeah. All right, guys, we will wrap it up there. Another great live Q&A. We were a little bit late getting started, but we're back every Wednesday, and it appears, at least more recently, that there's lives thrown in during the week as well. If you have not yet subscribed to our YouTube channel, please do that. Also, head on over to iTunes or Spotify, wherever you listen to your podcasts, find the Canadian Immigration Podcast and subscribe to that as well. And remember that our firm has a wealth of information in our blog posts. So go there and take a look at them. Some of the most recent ones we have: New Canada Minister of Immigration. What do we know and what to expect? Igor did that one. I did one on the new immigration measures to support housing. The express entry category change is what you need to know. Bridging open work permits. I think Alicia did that blog post. So we're constantly producing content in all forms for you. So whatever form you like the best, it's here for you. And if you need help with your immigration application, please slide over to our website, click on Speak to a Lawyer right here, and you can book a consultation with myself, with Igor, with Alicia. And very shortly, you guys, our lovely little pictures here will be modified because we're heading up, I'm heading up to Calgary to join Alicia and Igor and Prem to get firm photos taken tomorrow. So we're excited. We're going to have some new photos for our website. And I want to just give a big, huge shout out to all the people that have been leaving Google reviews for us. This is something that we've really started fairly recently. And it means a lot that we have this. Now, Alicia, I had a consult that I just had, and I'll finish off with this so you guys understand the world of our world here at Holthe Immigration Law. I had a consult with someone a couple of weeks ago, and in that consult, she asked a question that I really couldn't answer. It was something that there was no really right or wrong answer. And I said, let me take it away. I will see if I can find any other information. And then when I responded back to her about a week later, she wasn't satisfied with the answer I gave her, which was basically, I don't think you can do what you want to do. And she wanted proof from immigration that somehow this was barred or that there was some ineligibility and or something that would prevent her from doing what she wanted to do. And anytime I see a firm website that has a 5.0 star rating and, whatever, 206 reviews I think we have right now, I have serious concerns about that. Because sometimes, Alicia and I, the advice we give is not always what people want to hear. And sometimes they want us to say what they want to hear. But we're not hired guns. We're here to give you the information that is accurate, that is going to allow you to make decisions that are informed. And we're not here to just take your money and tell you what you want to hear, but we're here to actually give you legal advice that you can actually rely on. And sometimes, you guys, the advice is you don't have an option. And despite all of the sacrifices that you've made to be here, you may need to go home and you need to consider going home. And so all of the efforts that we've been putting in lately with our Time's Up series in particular, and now our Express Entry Getting It Right series, are designed to help individuals ensure that there is no mistake in their application that could have easily been avoided. But for those of you who are looking to retain and hire a lawyer to help you, we hope you'd consider us, that you'd book a consult with us, and then from there, look to see if we're a good fit to work with you in filing your application. And so subscribe to the channels, consume what we have on the blog posts, come join us live and give us shout outs. And we just love to hear from you. Subscribe to the DIY courses, the Express Entry Accelerator. Come join me every 2 weeks in the masterclass, which is more intimate than this. And and when you've got some really difficult questions, book a consult with Alicia. She's the smart person. All right, guys, thanks so much. I've got this other client who's WhatsApping me 3 times in a row, and 4 times. Wow, that's a record. All right, guys, have a great